Most people think estate planning means just one thing. I have a will, so my family, they're probably covered, right? Not exactly, because a will does not automatically avoid probate. A living will does not distribute your assets, and beneficiary forms can sometimes override what your will says entirely. That is where estate planning gets messy. People use terms they don't think they even understand, terms that can create completely different outcomes for a family. Court delays, family conflict, even assets going to the completely wrong person. So today, on a brand new episode of the Pursuit of Progress podcast, my co-host Ben and I want to simplify some of the biggest estate planning terms that people confuse all the time. This is not legal advice, but it will help you ask better questions and avoid these common mistakes. Because if you guys own a home, maybe you have kids, retirement accounts, life insurance, or you just simply want your wishes followed, this truly does matter, you guys. So, with all that being said, let's get into it. Ben, what's going on?
Hey, I'm so glad that we're having this conversation. I shared some of the same information on my social media accounts, just from some of the information that I've put together over the years, because a lot of the terms in estate planning sound very similar, but they mean very different things. And I was a little bit surprised because this stuff just blew up. Some of this information and some of these graphics that I shared got over 500,000 views. So it goes right in line with what I'm doing. And I think there's also a really big need for this because when you look at the baby boomer demographic, everyone keeps talking about the biggest wealth transfer in history, and it's getting ready to happen, and it is happening. Both of our parents are baby boomers, and some of that's tied up in real estate, retirement accounts. There can be heirs, there could be beneficiaries, there can be life insurance policies. So even though some of the stuff sounds the same, we're going to go through tonight and really break it down and explain the differences on some of the really key points. So I wanted to start off by talking about a will versus trust. Again, a lot of times people they think will, they think trust, they're thinking the same thing, but radically and very different. This is probably the biggest misconception that people have when talking about will versus trust. A will and a trust are not the same thing. A will gives instructions for what happens after you die. It can name guardians for kids, explain who receives assets, and appoint an executor. But here's the important part. A will still can usually go through probate if there's nothing else set up. A lot of people think, well, I have my will, so my family avoids court after my passing. Well, not necessarily. A trust is very different. A trust is what actually holds assets. And if it's created and funded correctly, certain assets may avoid probate entirely. So that phrase matters, funded correctly, because a trust with no assets inside of it is basically buying a safe and leaving it empty. Simple distinction: a will gives instructions, a trust holds and manages assets. When I set up my revocable living trust, I have a will that is incorporated into the trust. But then I have the actual trust set up. And as I get older and my needs change and my kids grow and get older, I will go through and revise that several times. So you can still revise the will and revise the trust as long as it's a revocable living trust. There's an irrevocable trust as well. And that is a trust that cannot be revised.
I'm just, as I listen to you talk, I'm just curious. It'd be fun to find out. Obviously, we can't do it for the show today for everybody, but just like what percentage, it'd be cool to see like what percentage of people even have a will at different age brackets. People that are under the age of 40, what percentage have an active will
hmm
where they've actually, fully written one out? How many people, what percentage of people above 50, above 60? I mean,
Yeah.
it's just crazy low compared to what we're probably thinking it is. And
And
what we'll
another
see.
good question to ask is when do you need to start really thinking about that? Like at what dollar amount? What, if you have a home or, what is the net worth figure or the asset figure? That's something to think about as well.
Yeah, and then the only other thing before we kind of get into the meat and potatoes of this episode, I'm also just thinking about AI and how it is changing the entire landscape of lawyers, what
hmm
kind of work is being done professionally versus DIY, do it yourself. I bet you there's going to be, fast forward 5 or 10 years, a lot of people that at that point are in this position where the will becomes a necessity where they need to figure out what's going on with things. And all of a sudden, these wills maybe aren't done in the correct way, or there's little things that maybe, were incorrectly done that now it doesn't, have the same validity or, you know, um, it won't count.
Yeah,
Anyways,
yeah, I
interesting
mean,
to think about that.
those are small details, but very, very important. And the probate rules, how money is passed through, it can really vary state by state. And so, a lot of and then some of that's already happening right now with some of these online resources like LegalZoom. You can fill out a form, you can buy it on LegalZoom, but it doesn't necessarily mean that it's going to be state specific or state compliant. And so that's where the estate planning piece is not just filling out the forms, but filling it out correctly, making sure it's notarized, and making sure that's going to hold up when it does go through the estate process, before and after someone's death.
Yeah, just for anybody that maybe is something a little new to them, when we're talking about probate, that's just referring to this period of time that happens after somebody passes on and dies, and just what is happening with everything. And until it actually gets finalized, it's in this, tentative probate stage. And this is really common, especially with real estate, where a lot of people that reach out to realtors like myself and need to sell their home because their aunt, uncle, parent, somebody passed away, and now they need to sell that house, which is in probate. So not to get in the weeds about that, but for any of you guys that are just kind of curious about some of the words we're talking about, that's what probate is referring to. A couple other words that we can kind of dive into. So the point that I'd first like to talk about is the differences between executor and trustee. So these both sound obviously very similar, but they do very, very different jobs. So first off, we'll talk about an executor, and this is the person that handles the actual will. So they step in after death, they gather everybody's assets, they pay off any debt, handle expenses, and then after that, they distribute the property according to what was in the will. So that's an executor. A trustee, on the other hand, they're the one that manages the trust. So that role may start while someone is still alive, maybe during incapacity or after death, depending on how that trust is actually structured. But an easier way to kind of think through all of this: an executor, they handle the estate through the will. The trustee is managing the assets inside the trust. And who you choose for these roles really, really matters a lot. So, if you guys are maybe at a phase in your life where you're starting to think about this stuff seriously, don't pick somebody simply because they're the oldest sibling or maybe the loudest, family member. Pick somebody that's organized, somebody that's responsible, calm under pressure, and I'd say more than anything, just capable of following instructions, because emotions are obviously going to be running very, very high after somebody passes away. And this poor communication is really what happens when it gets mixed with money. It gets ugly fast. So just really, really important to be thinking this through when everybody is capable and in a more sound state of mind.
Yeah, I think that's a great point that you made. Being able to handle the pressure. There's so many different dynamics of being either one of these, an executor or a trustee, and there's going to be a lot of family emotions. At that point, you're going to know what the will is, what the trust looks like, but then following through and making sure that you have the confidence to execute it and coordinate and not let somebody influence you in a way that is outside the wishes of the departed. So glad that you pointed that out. What I wanted to for my next talking point here, I wanted to talk about beneficiary versus heir. Same thing. If I ask somebody, are these synonyms? Are they the same thing? A lot of people would say, yeah, well, it's beneficiary and an heir. Yeah, I mean they're the same thing. Well, actually, they're not. This one still creates a ton of confusion. A beneficiary is someone you specifically name to receive assets. So they could be on a retirement account, a life insurance policy, a trust, a payable on death account, something like a 401k or an IRA. A beneficiary is usually your choice. What's different is that an heir is not. An heir is not always your choice, and an heir is usually determined by state law when there is no valid plan or no clear instruction. So in plain English, a beneficiary is who you picked, and an heir may be the person that the state picks. And people make dangerous assumptions here. They think, well, my spouse automatically gets everything, or my kids will just split everything evenly. That's not a plan. You might think that, you might say that. You can even have conversations with your family about that, but your verbal wishes are not going to be in the court of law, going through probate, and the state gets involved, they're not going to be considered. So that's why you need the plan. Put it in writing and make sure your beneficiary forms actually match your overall plan. On some of the asset accounts that I have, usually like with life insurance, with retirement accounts, you can actually name a beneficiary. So when I was setting up my trust, the beneficiary on the accounts that I have is my living trust. And so it just goes back to that. And then I have the will along with my other assets in my living trust. So it all flows back to that. And that's a great way to do it.
Yeah, and also I think depending on the age, it could also change. So, for example, when you have kids that are in their teens, like they are right now, maybe it's better to have like your brother, who's a very responsible person in your family, have him
Hmm.
be, that person in charge. And maybe when your kids are in their 20s or 30s and have a little bit more maturity, then maybe at that point you can always, switch some of the stuff up. Just making sure that the right person is always in the right seat at the right time.
Yeah, and that's an excellent point, and that's exactly what I did with some of my stuff. I'd have co-executors and co-trustees where different parties at different ages are going to be handling different roles. And I also wanted to make sure that there was some oversight as well, where one executor didn't have total control. There's co-executors; they both have to be involved in the process, and one is my brother, and then the other is my adopted father figure. But then, as you know, he's going to be 70 years old. I'm in my early 40s, and to your point, that's going to change over the next 10, 15, 20 years.
Mhm.
Yeah.
I think another term that you had mentioned earlier that I think some people might get a little bit of value out of diving into a little bit more is you mentioned the word revocable or the opposite, which is irrevocable. So just talk through a little bit the revocable trust and the irrevocable trust. So it's probably one of the most misunderstood areas. So a revocable trust can usually be changed while you're alive. You still maintain control. You can amend it, you can update it, or you can even cancel it if you need to, and that flexibility can be really, really useful. An irrevocable trust, on the other hand, is very different. So typically, once assets go into it, you give up a level of control. And why would somebody do that? I know you mentioned that you have an irrevocable trust. I think you said, right?
I have a living revocable trust, but when my dad died, a lot of times when somebody passes, it then can go from revocable to irrevocable. So my dad had a
Mm,
trust set up when I was a kid, and his trust turned into an irrevocable trust after his passing.
got it. Okay. So just talking through though again, like about the irrevocable trust. Once assets go into it, you're giving up that level of control. So why would anybody do that? Well, in certain situations, it can help. So, for example, estate tax planning, maybe
Hmm.
protecting some of your assets. If you have Medicaid, just planning out some of that. Also, legacy planning. But there's a trade off to this too. So, more protection often means less flexibility. So, anytime somebody casually says, you should just put this in a trust, the next question should always be, well, what kind of a trust? And I think just as important, what problem are we trying to solve? Because there's so many different dynamics, different levels of complexity when it comes to this stuff. It's not just one answer for there's not a blanket answer for everybody.
Yeah, and that's always the best way to approach it. What are we trying to achieve here? What problem are we trying to solve? And that's, I learned that in the mortgage and real estate world. You can't just put a cookie cutter scenario for every single person because it depends on their income, their goals, their occupancy. Why are you doing this? What's the long term goal? The biggest thing, though, is that again, kind of to your point when we started this podcast, how many people have that plan and that vision? And that is where it is so important. And in my mind, if you have a net worth of over $100,000, or if you own a home, if you're a homeowner, if you have any large ticket assets, you really want to start to consider some estate planning. And I would call it more advanced estate planning, but it's not, that sounds so big and crazy, but you want to make sure that you have the structure and the principle and all of this built out, and it does not require as much time, energy, and resources as you're probably thinking. Just requires a little education. You want to make sure that you're talking to someone who is a certified professional, and it can be done for a very reasonable cost, whether you do it on your own or you hire a professional. Another point that I wanted to talk about was the living will versus the last will. And these two also get confused constantly. So, a living will is about medical decisions while you're alive, things like life support, resuscitation, end of life care, medical wishes if you cannot communicate. A last will is about property after death. That's the document explaining who receives the assets, who handles the estate, who may become guardian of minor children. That's your post life wishes. So, a simple memory trick: living will is medical wishes, last will are your property, your asset, and your debt wishes. And honestly, incapacity planning is one of the most overlooked parts of estate planning. People focus on entirely what happens after death, but sometimes they forget to plan for what happens while they're still alive and unable to make decisions. And again, this is why you want to make your wishes known, not just verbally, but you want to make sure that they're written down and your family members know and that person is designated. Here in the last month or so, my great grandfather, through my adopted family, passed away, and he had a stroke back in March, and um, was in a assisted living facility for a while, and then over the course of 30 days, his body just started to shut down, and that was my first time experiencing that, what that looks like, and there was a period of about 2 or 3 weeks where he was alive, he was, cognizant, he could make eye contact, but he wasn't able to communicate, he wasn't able to express himself, and so going through that really just gave me a little bit of a different perspective seeing that firsthand.
Yeah, and I need to double check this. I don't want to be telling everybody incorrect information here, but I think as long as you just have it notarized, so I think this would be a great the living will would be very easy to do. I think even just with maybe using Chat GPT or just even just a Word document and just again think through all of the living will related stuff. You know, what do you want to have happen to your organs? Would you like to be cremated? All those types of things. You could probably even get away with doing this for next to nothing, meaning that you could probably just put this on a piece of paper, and as long as it's notarized, I think that's considered valid. So, even though it's a pretty serious thing, I think it's pretty easy to do. So don't let this kind of overwhelm you guys if we're talking through a lot of this stuff and it just seems like just a laundry list of expensive things that you have to do. I think some of this really can be done pretty easily and inexpensively. I'd like to talk now about probate versus intestate. So another major misconception, as you guys can tell, all of these are, misconceptions to one degree or another. But people really do think probate only happens if there is no will, and that's wrong. So probate is simply the legal court process for settling an estate, and that can happen with or without a will. So the word intestate, that just means that someone died without a valid will. So probate is the process, and then intestate is the status. And this is why understanding things like title, trusts, beneficiary forms, why it matters so much, because the goal is not just to have these documents. The goal is to have a plan that actually all works together. And I think that's another area that, a lot of people probably miss.
Yeah. Yeah, you put the plan and the vision together, and then these are your pillars that are the foundation for your plan, while you're alive and then afterwards. And a lot of people think that estate planning is really focused on after death, but as we're discussing, there's a part of it that is very important while you are still alive. These are types of conversations that I have had with my kids. They know about my trust. Is something that we talk about. I want them involved, but as they grow and mature, they are going to have different roles. Just because my son is older, my daughter is younger, and vice versa, it doesn't mean that they're necessarily going to be in this role or that role. We're going to determine what is best for the estate and the legacy, and then we're going to set it up in a way that it's going to be able to continue to hopefully serve them and future family members down the road. My great grandfather, who was born in the 1800s, just think about this, and as far as legacy, he was born in the 1800s, and I met him. I was about 4 years old when he passed, and he passed about 95, age of 95. But he had set up a trust, and the trust was just recently closed, uh, roughly 40 years after he passed. And, it was something that had been set up roughly like 80 years ago. And it had served like his children, who was my grandma, and then, her kids and the other, and all of a sudden there's a laundry list of like 60, 70 people that are part of this. And so it was something that I was like, it was kind of like my aha moment. I was like, wow, so this is what this can look like when it's done correctly.
That's a legacy. That's really cool.
Yeah,
What
yeah.
an honor, for him to know that well after he's gone, before he's even met the generation after generation, that they're still benefiting from his hard work, his success, just from his, intentionality with putting this together. That's awesome.
Yeah, and I don't know if I ever shared this with you, but he was a businessman and an investor and a landowner, and he sold a huge part of his land, including the caves. In Kansas City, Missouri, they have like these underground caves. I think it's called like the Metropolis, underground Metropolis. So, anyways, he sold that and all of this land to the Hunt family. So where the Chiefs play and the Royals play, like he once upon a time owned all that land and that was sold to them along with, a lot of other stuff. And it's something that we always kind of like joke about a little bit.
Yeah, was this great grandpa, was he a Broncos fan or was he a Chiefs fan?
He's actually born in Denver,
Okay.
ended up living in Kansas City, went to CU. So he is a buff, but I don't think the Broncos existed
Yeah, true. That's what I was yeah.
or the Chiefs, for most of his life. So
Let's wrap this up. Talk a little bit now about and I'm not even sure how you pronounce this last point that you presented for everybody. Going into this last one.
I have such a difficult time with the pronunciation on this one as well. I was hoping that you were going to say it. But this last one is per stirrups versus per capita. So if it sounds like we're descending into ancient Roman battle terms, well, we kind of are because the language here, kind of the further down we go, the more kind of ancient some of the language gets. But these still matter more than people realize. And the per stirrups stripes. I don't know. It's spelled STIRPES. And so these are the terms that determine what happens if a beneficiary dies before you. So you name a beneficiary, and then this is what determines what happens if the beneficiary dies before you. So per stirrups usually means that child's share passes down to their children. So that family branch still inherits what it was supposed to, even though the original beneficiary passed. Per capita usually redistributes the inheritance among surviving beneficiaries at the same level. So very, very different terms. So, let's say that there's 5 kids and you have the grandmother and the grandmother has 5 kids and then all of the 5 kids have 3 kids. So under the per stirrups, let's say that the oldest sibling died, that money or those assets would still pass to her family branch. Under the per capita, they would not. They would go to the remaining first generation beneficiaries. So again, the per capita usually redistributes the inheritance among surviving beneficiaries at the same level, meaning grandchildren could unintentionally get skipped. This is a massive difference created by two small phrases, one of which I'm not pronouncing correctly. And most people signing documents, when you're going through something like this, you really have no idea what you're signing, or there can be so much information here. You think of a real estate package or a mortgage package. I went to a closing earlier in the week. The real estate and loan package is literally like 200 pages.
Hmm.
If someone is going to go through and read that, it would take them all day, and that is not an exaggeration. So these terms, you have to know what to look for. Massive difference created by two small phrases, and most people signing these documents would have no idea what either one means, and that's why you need to ask the questions that actually matter.
Absolutely. Well, I don't know about you guys. I don't know about you, Ben, but for me, I think probably the biggest takeaway from this entire episode is just hearing you keep talking about these beneficiaries and how beneficiary forms can definitely completely override your will. So again, that includes retirement accounts, life insurance policies, payable on death accounts, transfer on death accounts. So if you guys already do have a will and it says everything goes to your current spouse, but your old life insurance policy, for example, still lists your ex spouse, that can create a major problem. So
Yeah.
your estate plan is not one document. It's a lot of things. It's your will, your trust, your deeds, your account titles, your beneficiary forms, your healthcare directives. What do pull the plug, keep you on life support, whatever it may be. All these different pieces, they all need to work together and cohesively because your estate plan is only as strong as that weakest, outdated form and is so, so, so important just to make sure that you have everything in alignment.
Yeah, hopefully all this beneficiary talk has been beneficial to our listeners and viewers. And just remember this as well, estate planning isn't about being rich. You don't need to be rich or be someone that has a high net worth or own 100 properties or have millions upon millions. This is about being clear. And these terms might sound similar, but they create very different outcomes. The goal isn't to become an attorney overnight. The goal is to ask better questions before your family is left cleaning up the confusion later. A good estate plan doesn't just remove grief, but it can remove stress, delays, arguments, and uncertainty. And when people you love are already hurting, that really does matter. Well, we appreciate you guys for listening to another episode of The Pursuit of Progress. Until next time, keep moving forward. God bless. I'm Ben Adams for Adam Lang. We'll see you guys next week.
Catch you guys next time.